Our second case today is Cassandra Harris versus Stephen Plapp. If you are ready, counsel, you may proceed.
Thank you, Your Honor, and may it please the Court. My name is Jonathan Wyrick. I am here on behalf of the appellant Cassandra Harris. She's actually with me here today at counsel's table to observe. Before I proceed, I would ask to reserve 2 minutes of my time for rebuttal.
So noted.
Thank you. This case is a defamation action. This, in the trial proceedings below, this proceeded before the bench. The trial court made a number of what we contend are erroneous as a matter of law rulings as to conditional privilege of the alleged defamatory material, as well as not basing the award of damages in the case on any substantial competent evidence. Those are the two issues that relate to trial. The third issue that is before the court is whether or not the offer of judgment that was served prior to trial and was later ruled to be valid and an award of attorney fees was entered on, whether in fact that satisfies Florida Statute 768.68, Florida Rule of Civil Procedure 1.442, as well as Diamond Aircraft v. Horowitz, the Supreme Court's decision on how to determine if an offer is acceptable based on what kind of relief is being requested in the action. And we believe with the arguments that we presented that on all three of those issues, the trial court erred as a matter of law and didn't base its findings of fact on any substantial competent evidence at trial. The first issue then, going directly to my argument, and before I begin that, would the court care for a brief recitation of the facts and background, or do you want me just to go into my argument?
I think you can jump right in.
Absolutely.
Okay, thank you. The first issue then that we bring up is this idea of qualified privilege. There's actually a case out of the first district here, Denby v. English, that we relied upon for the proposition that a defamatory statement, even if it is actionable per se, based on the language of it, it's untrue, it meets the characteristics of defamation. If it is sent in good faith and, importantly, by someone with a duty or interest in the subject matter of the correspondence to another person who has a corresponding duty or interest in the subject matter, that is actually cloaked in a presumption of good faith at that point, and the burden then shifts to the other side, or the plaintiff in that case, to rebut that, either through abuse of that conditional privilege or express malice, and there are several ways to determine that.
So how broad is that scope of that privilege and that shared relationship? So, first, start out by explaining that shared relationship here.
Well, so in this case, Your Honor, my client is an African-American woman who got involved in swim meet refereeing as a result of the accidental drowning of her son. It was a very tragic event in her life. She began actively participating, getting her certifications. She's a retired police officer in Chicago, and as part of her journey in meet refereeing, she met a fellow African-American man who was also a meet referee who had been doing it much longer than she had, named Mr. Thompson. That is the mentor that she described in the trial transcript below. And Mr. Thompson was a gentleman who the third-party witnesses that the trial court ruled were credible claimed was a mentor to many of them, and in fact would likely have been a mentor to Ms. Harris.
And what was the nature of their shared interest?
The nature of their shared interest is multifold. First of all, the letter itself, it's worth pointing out that the letter itself is not simply a one-paragraph letter saying, I saw Mr. Plapp and he was dangerously intoxicated on the deck, and that's it. It's actually 12 or 13 paragraphs describing a variety of different issues.
And I think we understand that, but again, succinctly, what is the shared interest between the appellant and Mr. Thompson?
The shared interest in this case, Your Honor, is that they both have an interest in bias and racial discrimination and disparate treatment within these events. They have an interest in the safety and adherence to swim protocol within their sport, as that's what they're actively involved in, how they knew each other. And they also have an interest in ensuring that the volunteer environment is safe and non-hostile.
And those are very broad interests. So did Mr. Thompson work for the same organization?
Mr. Thompson was a member of Florida Swim and USA Swimming, which are, I guess, some of the same organizations that were, I guess, presiding over the Bowls event, which is the swim event that is the subject matter here.
Was it the same organization, though, that was in charge of officiating for the Bowls event?
I don't know at the time that she wrote that letter if he was.
And what I'm getting at is, so let's assume the appellant reached out to the International Olympic Committee that shares all of these same interests that you've described. Would that have enough of a relationship to be a qualified privilege?
Your Honor, I think that depending on the circumstances of the relationship, it would depend. Is the person, in your hypothetical, is the person in the Olympic Committee somebody who has worked and knows personally many of the people who are working at this event? Because that was the case with Mr. Thompson. Mr. Thompson knew many of these people. In fact, the only way that the regional head of the event, Mr. Powell, and several of the other witnesses that came about to testify even found out about this was because Mr. Thompson knew to forward it to them. Because it was their jurisdiction to oversee this type of thing.
There's also dispute below about really what the nature of the relationship was, right? Like how close they were, and Ms. Harris's testimony about, or maybe perspective of how close they were, didn't necessarily line up with other people's explanations of the nature of the relationship.
Well, respectfully, Your Honor, I actually don't agree. I cited in my initial brief to a point where even Mr. Plapp admitted that he thought that Mr. Thompson would have been a mentor to Ms. Harris. But it's not necessarily was there a mentor-mentee relationship. What the court in Dimby found is that you're focused not just on this legal or it's not just a legal duty or a contractual duty that creates this bond. It could be a social or moral interest. And I think we have that here present, but as I illustrated to you, Your Honor, I think that the interest was clearly satisfied here. Mr. Thompson, again, was a respected member of this community. He knew all of these people who were officiating at the Bulls meet. He sent the correspondence to the persons who began investigating all of the allegations that are contained in here, not just the ones about Mr. Plapp. There were allegations about Mr. Fox. There were allegations about people being kept on shift too long in the sun and getting heat stroke. There were a number of different issues, and all of those issues were being investigated, and that was what the testimony was below.
Let me ask you about the good faith issue. So there's different evidence put on below about the intent, and ultimately the trial court makes a finding that's adverse to Ms. Harris, that she was not acting in good faith, that she had concocted this story and fabricated this story. Why is that not entitled to deference for our appellate review?
For several reasons, Your Honor. First is because there was no evidence presented below that Ms. Harris concocted this story. One of the things that is conflated in the trial court's ruling and also in the answer brief is that there were a lot of witnesses who came forward and testified, we didn't witness Mr. Plapp intoxicated at any point. But simply proving that he was not intoxicated does not prove that Ms. Harris concocted her story. She could have been mistaken. There could be any number of issues, but it's speculation at that point. So that's the first issue. That's a problematic thing.
And I just want to stop there. So the trier of fact was not entitled to draw an inference that the only person that suggested that Mr. Plapp was intoxicated was appellant, that he could not draw the inference that, in fact, he wasn't. Is that what you're suggesting? That all of those witnesses came forward and said either affirmatively, I didn't see that in him, or I didn't notice?
I'm not suggesting that an inference can't be drawn in some circumstances. I just don't see how in this case you can make the leap that it was a concoction of whole cloth to the degree that it actually constitutes one of the exceptions or to overcome the good faith, right? Which is either that the process was abused or that there was express malice in communicating the alleged defamatory statements.
Well, what evidence would have been required? Did you need a blood alcohol level for Mr. Plapp to be able to, conclusively establish that he wasn't intoxicated?
No, Your Honor, I think an example of evidence that would have been, an example of evidence that would have been persuasive on this regard would have been if Ms. Harris was on record telling her friends that she interacted with Mr. Plapp that day and didn't notice anything wrong, or she recounted her account to some other witness and never mentioned Mr. Plapp once as being intoxicated. In that situation, yes, maybe there is an inference that can be drawn from the fact that Mr. Plapp was not intoxicated. But simply in isolation, under the facts of this case, I don't think, especially when you consider, again, not my client's testimony, but the evidence that's actually there, right, which is the letter itself. I don't think that you can conclude, based on that evidence, that she concocted the story purposefully with the primary purpose to harm Mr. Plapp. Again, that's one of the ways of showing express malice. And in fact, the reason I know that to be the case is because in the transcript below at closing arguments, Mr. Plapp's counsel actually didn't ask the court to find that the primary purpose to harm Plapp was based on some sort of extrinsic evidence. He actually argued, and this is on this is the transcript 962, that in fact it was the nature of the statements themselves that showed this express and extrinsic malice, such that you could overcome the presumption of good faith.
Let me move you to a different issue as we run through our time here. So let's talk for a second about the attorney's fees issue.
Yes.
And the settlement offer. I think there's some interesting issues there, but in my review of the record, it looks like the order that the notice of appeal was filed for is the order of the trial court granting entitlement to fees. I don't see in the record where there was a notice of appeal filed for the actual order granting the amount of fees, the final order. Is that procedurally, does that put it properly before the court for our review?
I don't think so, Your Honor. We never raised the issue of whether or not the fees were reasonable that were ultimately awarded. The issue before the court is whether or not there was an entitlement at all pursuant to this offer of judgment. And it is obviously our contention that there is none.
Is that a final order? Is the order of entitlement a final order that's subject to appeal?
I believe that it is, Your Honor, because it is subsumed within the final judgment that it was ultimately entered. And if it was a post-judgment final or a post-judgment order, generally speaking, those are separately appealable because they're post-judgment, so there isn't any additional judicial labor. And in this case, though, because the award is incorporated within the final judgment, which is what's on appeal, I think it's properly before the court, even though we're not contesting the amount side of it.
Okay.
But with regard to the offer itself, again, I think no matter which way you look at it, the appellee brought up an argument that because the written retraction and apology contained within the offer was actually unauthorized relief under Florida law, that citing to a Middle District case, that meant that the offer was fine. But as I point out both in the reply brief and argued in the initial brief, Florida law is very clear. The offer of judgment statute's intent is to allow litigants to look at their case, evaluate it on a monetary basis if it is in fact an actual damages case, which it must be, and determine, should I accept this offer or should I take my chances at trial? They can assess that, they can do the calculation, they can figure out, do I meet the 25% threshold or not, and so should I take this offer or should I not? In this case, the reason why no matter which way you look on this issue, you have a fatal defect is because that public retraction and injunctive relief, however it's termed, is included in the offer itself. In other words, my client is no longer able to make that calculation under the statute. Diamond v. Horowitz would apply whether or not this relief is authorized or not, because it's a part of the offer. It has to be overturned on that ground. Your Honor, respectfully, before the court, the record below simply doesn't support the trial's rulings, either on conditional privilege, on express malice. In many cases, I point out that the trial ruling even contradicts itself in certain instances, and as to the issue of damages, there wasn't any substantial competent evidence to prove $25,000 in emotional damages or $25,000 in reputational damages, because every witness that testified at trial said that Mr. Plapp's reputation did not diminish to them. And with that, I see my time is concluded, and I will be back up here on rebuttal. Thank you.
Counsel, I'll note that you actually used all of your rebuttal time. I will give 1 minute to you for rebuttal, and I'll also add a minute for the appellee.
Good morning, and may it please the court. I am Scott Sheftel for the appellee, Stephen Plapp. My esteemed colleague has argued that the factual record below is insufficient to support the extensive and meticulous findings that Circuit Judge Aho entered into the record, both over about a 16-page recitation of her findings of fact and conclusions of law that she recited from the bench at the conclusion of this lengthy trial, and once again in a 13-page memorandum final judgment in which she meticulously went through every element of actionability of the one count for defamation money damages, and also she went through every single element prescribed by the Nodar decision and its progeny to determine whether applicability of the common law privilege, conditional privilege, even applied in the case.
Very good. Let's start, counsel, if we
Your
could,
Honor.
with the factual findings. And given the latitude that Judge Aho had to make those factual findings on this record, would you concede that, let's start with the malice side of things. If Judge Aho had looked at the record and said, with regard to the inebriation, assertion, that she found that appellant didn't act with actual malice, would you concede that you wouldn't have an appealable issue if that had been her factual finding?
Well, Your Honor used the term actual malice. Of course, that's the constitutional standard.
Right.
Here we're speaking of express common law malice.
Yes.
So translating your question, Your Honor, if I might just rephrase it, you're asking whether if Judge Aho had found from the record or had been unable to find from the factual record evidence to support a finding of express malice, would we have been able to prevail? Is that the court's question?
Well, let me make it a little more concrete. So, with regard to the assertion by appellant's counsel that all of these witnesses, some of them testified that they didn't see Mr. Plapp inebriated, and that wasn't enough to show the appellant, intended to speak a false statement about Mr. Plapp. If the trial judge had said, you know what, that's not enough to show that intent, would you concede that you would not have an appealable issue if you had not prevailed?
If I apprehend Your Honor's question, I think it was incumbent upon Plaintiff Plapp to make a persuasive factual record by a preponderance of the evidence that the defendant had acted with express malice.
And so what evidence was there beside the written statement itself of express actual malice?
Your Honor, really the evidence was overwhelming. And I begin with the court's finding that the defendant had made up the story. She had concocted it. There was no factual basis whatsoever for a reasonable person to suspect or infer that Mr. Plapp had been intoxicated and had himself become a danger to the children in the pool during this bowl swim meet. The Randolph v. Beer case makes clear that when a defendant in a defamation case concocts the story, makes it up out of whole cloth, with no basis upon which to make a reasonable inference that it might have been the case, that in and of itself is sufficient to show express malice. But there was much more. We proved express malice via both prongs of the Nodar decision, both by the intrinsic evidence of express malice and also by the nature of the words themselves, the character of the words themselves, which, as Judge Aho correctly found, were, and I believe I'm quoting her, a very, very serious charge against Mr. Plapp, because he wasn't just being accused of imbibing an intoxicating beverage, he was accused of being dangerously intoxicated while serving as the deck referee at the bowls meet, where the safety of the children in and around the pool was of paramount concern. And as it was of paramount concern to the USA Swimming organization, in fact, if it had been found that Mr. Plapp had had alcoholic beverages with him or had consumed any around the children, it would have been a direct violation of a specific provision in USA Swimming's Code of Conduct. Judge Aho recognized what serious charges these were. She took pains to explain in her recitations of findings and in the final judgment that she had taken great care to examine and observe each and every witness. In this case, we adduced evidence from 10 distinguished witnesses whose testimony uniformly established that Mr. Plapp had not been intoxicated, and furthermore, that there was no basis to think that he had been. Sue Talwer's contemporaneous written report, after interviewing Mr. Plapp 2 to 3 feet away from him, not once but twice, once that morning and also that afternoon, gave him the very highest marks for conduct. There was no suggestion to her or to any of the others who testified that Mr. Plapp had been intoxicated.
What about the evidence regarding the privilege? Or what about the issue of privilege?
Well, the Nodar conditional privilege, Your Honor, in order to apply, it must be established that 5 elements exist. And in our brief, we pointed out how Judge Aho carefully went through every element of the Nodar test and found that the privilege did not apply. And the first element, of course, is the element that you, Judge Rowe, and you, Judge Long, have asked about, which is whether there was good faith or bad faith. If bad faith, the qualified privilege cannot apply. If good faith, then you go to the next element, which is, of course, whether the defendant espoused a legitimate or credible interest in the subject matter about which he claimed an interest or duty to speak, namely racial discrimination. Your Honors, if ever there was a pretext brought into trial at the 11th hour as a Hail Mary by a defendant who clearly has committed defamation, it was the defendant's assertion at trial for the first time that she had been the victim of racial discrimination, or that she had perceived herself to have been such a victim, and therefore that's what motivated her. This was never raised during discovery. There was no interrogatory answer touching on such an issue. In her sworn deposition, she never made reference to it whatsoever.
Well,
But
what
more
about her
importantly-
what about her statement itself? I mean, the very statement discusses bias. What was that referring to?
Your Honor, I'm sorry, I couldn't hear you.
The alleged defamatory statement itself raises the issue of bias.
It does not raise the issue of racial discrimination. It was a concocted story in order to give her leverage, the leverage she sought, to obtain qualifications as a USA Swimming official in Florida without having met all the qualifications. Judge Aho carefully studied these issues of fact, and she made exquisite, specific findings of fact on that very point, Your Honor. And I don't see how a trial judge could have been more explicit or could have taken greater care in examining the evidence in the record. And she found, and I'm not able to quote her because I don't have it in front of me, but I'm sure I can accurately paraphrase it. She found that there was no basis whatsoever to support the contention first raised at trial, that there was any racial animus involved, any basis for Ms. Harris to perceive racial prejudice of any kind. And so it was just a pretext, Your Honor. It was one of the many untruths raised by the defendant in this case.
What about the argument by your esteemed colleague that there was insufficient evidence on damages?
He insinuates that the only evidence of damage was from Mr. Plapp himself, and he also asserts that Mr. Plapp only cared about the retraction, getting his reputation restored. Neither of those contentions is accurate at all. Mr. Plapp testified at length, and I have covered much of the evidence in our brief about the non-monetary injuries, actual injuries he suffered from the defamation in the form of emotional injury. His extensive answers on those points are detailed in the brief, and the reputational injuries were also detailed in the evidence, and not only by Mr. Plapp, but by several of the other swim officials who testified. There were 10 swim officials, all very distinguished individuals who were brought before the court and placed under oath. They testified uniformly that Mr. Plapp had not engaged in any of the conduct that he was accused of having engaged in, and several of them testified that they had witnessed behavioral changes in him on account of the stress and humiliation that he had suffered as a result of these statements. And further, there was evidence as to how serious these charges were for a man who over 20 years had served as a voluntary swim official in over 500 swim meets. Truly one of the most distinguished swim officials in Florida. And to have, one can hardly imagine more serious defamatory statements made about such a swim official as the ones that Ms. Harris placed into her memorandum, which was addressed to no particular person and not dated, which they call a letter. And then she distributed it first to a woman named Witherspoon in Chicago. That publication she sought to conceal all through discovery. And the court made a specific finding about that concealment. Ms. Witherspoon was not an official in Florida swimming. She was in no way involved in the Bowls meet. She passed the memorandum on to Mr. Thompson.
Let me ask you a question about the last issue, the settlement offer and the attorney's fees issue. You seem in your briefing, I think, to acknowledge that 768-79 is only applicable to a money judgment, and to defend the offer that wasn't in conformity with 768-79 by saying it, the demand for an apology was not legally cognizable. Do you think that, or talk to me a little bit about why or how she could accept your offer as offered if it includes things that you acknowledge are not legally cognizable?
Judge Long, I have about 2.5 minutes left, and I do want to cover my position on the validity of the proposal for settlement and the award of attorney's fees in some detail. The reply brief cited 8 cases in support of its attack on the proposal for settlement. Not one of those cases was cited in the initial brief, and I reacted to that by filing a notice of supplemental authority, the land case for the proposition that they had abandoned that argument by not raising it in the initial brief. My duty of candor to this court compels me to clear the air on that. I was moving my law office at the time. I didn't go back and study carefully my own answer, their initial brief and my answer brief at the time like I should have. I've since done that preparing for oral argument. They did not fail to raise their argument in their initial brief. So I've apologized to my learned counsel for insinuating an abandonment. I want the court to know I'm not arguing for abandonment. But I am strenuously arguing that the proposal for settlement is valid. And I want to try to cover the salient points, many of which are supported by the cases cited in the reply brief, which actually support my position. Now, of course, this was an action for defamation damages. A private figure plaintiff filed a complaint for damages against a non-media defendant. And Mr. Plapp had to prove as a fundamental element of his cause of action for money damages under his claim for defamation that the defendant Harris's statements about him were untrue. Whether the statements at issue were true or untrue was not only central to the cause of action to recover money damages, that issue was an element of the cause of action for defamation. It was, Judge Long, it was intrinsic to the cause of action for money damages. It was not extrinsic. It was not a separate cause of action. Now, by including
Counsel,
an
your
explicit...
time has expired, but I'm going to give you about 15 seconds to wrap up.
15 seconds. Your Honor, the Plapp was not causing Harris to give up a claim or right that she could not have otherwise lost in the trial for defamation damages. If she didn't accept the PFS, she was going to have to litigate whether or not her statements were true. The plaintiff could not have recovered money damages, Judge Thomas, if he had not been able to prove the statements were false.
Counsel, you have exceeded your time. Thank you for your argument.
Thank you, and the court will find this language in the cases cited. Thank you.
May it please the court, and I appreciate the court's indulgence in allowing me to go over, and also my fellow counsel. I just want to respond very briefly to the assertion that racial discrimination or bias was not a topic of interest contemporaneously with this letter going out. In fact, if you look at the trial transcript on page 136 and 135 before it, Mr. Fox, who was one of the primary topics of complaint, let's just say, as to how the Bulls meet was being held, actually raised that issue at trial, that when he was looking at this letter, racial discrimination was a topic that was being discussed. So that wasn't something that was just concocted out of thin air. And that obviously, as I point out in my initial brief, contradicts what the trial court ultimately found. I will submit the remainder of my argument on the briefs. Thank you very much for your time today.
Thank you, counsel. Thank you all. This court is adjourned.